Hello, and welcome to another edition of Chambers Expert Focus. This conversation will focus on litigating non-compete agreements before the Delaware courts, and I'm delighted to be joined today by Michael C. Rakower, founding member of Rakower Law PLLC. Michael will be discussing the factors Delaware courts use to assess the enforceability of non-compete agreements, and he'll also be explaining the role forfeiture for competition provisions play as an alternative to non-competes. Welcome, Michael.
Thank you.
Thank you so much for joining us. If we could just begin with the basics, what actually is a non-compete agreement?
A non-compete agreement is an agreement between typically an employer and employee in which the employee promises not to compete with the employer following termination of employment. The non-compete is limited in scope and geographic scope and duration based upon the terms of that agreement. Non-competes are controversial in today's world because they are a form of restraint of trade, and courts generally in the government have been concerned about restraining an employee's right to work. The Federal Trade Commission sought to impose a nationwide ban on non-competes, but that ban itself was struck down by a federal court, so they still are permissible, and states across the country are grappling with their enforceability. Delaware is a state where many companies across the country are incorporated. And so courts do look at what Delaware does in this space to develop a sense of maybe what they should do. It's certainly a pivotal place in the jurisprudence on this issue. And as a result, as a New York litigator, I recently was litigating in a Delaware court the enforceability of restrictive covenants generally and a non-compete agreement specifically.
Got it. And having established the importance of Delaware, and we'll avoid a potentially fascinating historical digression about why Delaware became the state in which to incorporate, I think the next question really is, do Delaware courts enforce non-compete agreements?
They do. Delaware courts will enforce a non-compete with a caveat. They are concerned about, they have policy concerns concerning restraints of trade generally. That's on the one hand, but on the other, they do respect the right of parties to enter into a negotiated contract. And so to balance that tension, they want to make sure that the non-compete is, quote, reasonable. And if the non-compete is reasonable, then they will enforce it. But if they feel like it's not reasonable, then they won't enforce it.
So that reasonableness standard is obviously key. How do Delaware courts decide whether a non-compete is reasonable?
Delaware courts use a three-part test to determine the reasonableness of a non-compete agreement. First, the non-compete needs to be reasonable in terms of geographic scope and temporal duration, meaning time and space. Second, it needs to enforce a legitimate economic interest. And third, if one balances the equities, the court needs to believe that equity lies on the side of the employer in trying to enforce the agreement rather than the employee trying to overcome the agreement.
Great. So let's get into a little more detail and think about how, in practice, these factors are applied. Let's start with the geographical scope and the temporal duration.
Sure. The geographic scope and temporal duration factor work together. So, common sense wise, the broader the geographic scope, the shorter the duration, the broader the duration, the shorter the scope. But they both work hand in glove, and the court looks at them to determine whether they come across as reasonable. So, if it's a year or less, that will oftentimes be reasonable. If it's more than a year, it's going to be suspect. If it's a 5-year non-compete, it's going to be very, very, very hard to enforce. Similarly, if the geographic scope of the non-compete is limited, let's say, to certain zip codes within a city, that sounds like it's carefully tailored. If it's a multi-state geographic scope or a national scope, it's going to be subject to a higher level of scrutiny. There are times in which a court will impose a nationwide scope, will apply a nationwide scope to a non-compete, but very often that's not going to be the case because the court recognizes that an employee needs to be able to work And if they're barred from working anywhere in the country for some period of time that's material, the court's likely to find that kind of broad geographic scope to be unreasonable. But ultimately, it's going to be, they're going to look to the next question, which is the legitimate economic interest. So with that prong, the court wants to know why the company wants to impose a restriction on this employee. They typically want to see that the employee is kind of a linchpin or high-level employee before the court's going to recognize a legitimate economic need to impose the non-compete. The kinds of factors that the court looks for are whether the non-compete was a condition of employment in the first place. Was the employee on notice at the time he or she started working at the company that they were imposing a non-compete on him because he was to be a critical employee of the company? If that's the case, signing a non-compete at the outset with that kind of warning seems to militate in favor of enforcing it. Similarly, if the employee gets a promotion, wasn't previously subject to a non-compete, but now, as a condition of the promotion, will be subject to a non-compete based on the recognition that the employee is now moved up into a higher echelon of status, and the information provided to the employee now is going to be competitively sensitive. The court may enforce the non-compete under that type of scenario. The third scenario that's probably the most protected is in the sale of a business. If someone sells a business and as a contingent to selling the business, they have to sign a non-compete, the court's going to be pretty comfortable enforcing not just any non-compete, but even a broad geographic scope non-compete, because the court recognizes that the individual was paid a large sum of money, oftentimes in the multi-millions, to sell his business. And the buyer doesn't want to then have to compete with that person who built the business, who might start a new business and then compete. So in that scenario, if the seller receives a premium, many millions of dollars for the sale of his company, it's quite reasonable to then enforce a broad non-compete against that person for some important period of time so that he doesn't start a new business to compete with the buyer who just bought his business.
Interesting. Well, I mean, there's such a range of factors there, so it's going to become very much fact dependent, I suppose. Got to take each case in turn. Let's turn now to that second factor and what counts as a legitimate economic interest?
Well, we just touched on one. If you sell your company, for example, then the buyer is going to have a legitimate economic interest in preventing you from competing with that company for a reasonable period of time and reasonable geographic scope. Similarly, if you're a high-level employee and you know competitive information about the company, you know its strategic growth plan for the next 12 months, for example, or you're aware of a product that it's about to roll out that's going to change the industry. That kind of competitively sensitive information is something that a company has a legitimate economic interest in protecting. So the court is going to recognize that sort of legitimate economic interest when evaluating the reasonableness of the non-compete. Now, on the flip side, if you have a contract that pays lip service to the economic need and just says in the agreement, there is a legitimate economic need here, but doesn't explain what that need is, the court is going to look right past that lip service and look to the heart of the matter and ask whether there actually is a legitimate economic need. Similarly, sometimes agreements will include a representation by the employee that the non-compete is reasonable and legitimate and fair in terms of geographic scope and duration. The court's going to look past that representation as well, because it has an independent responsibility to determine the reasonableness of the non-compete, and will pretty much disregard a representation by the employee because it will be assumed that that kind of representation is boilerplate, foisted on the employee by the employer. And the court will want to know, brass tacks wise, whether that non-compete is fair and reasonable under the circumstances. And that
And-
gets us to the third prong.
I was going to say the third pillar of that reasonableness standard we mentioned, which is, courts balancing the equities. If you could expand a little on that for us.
So the balancing of the equities is a multi-factored test. It's subjective. It can't be codified in some kind of specific form of analysis. It's a kind of a touch and feel. If you balance the equities, if you look at the plaintiff's, the employee's position, if you look at the employer's position, does it seem fair? That can be a tough one for either side because there's a variable there that you just can't predict. But it's kind of a catch-all mechanism that the court can rely upon to ensure that it's doing what's fair. Some of the factors that the court may consider are whether the employee had a reasonable opportunity to negotiate the terms of the non-compete. What kind of bargaining power do the employee have at the time? Employee has a lot of bargaining power at the outset of a relationship, but when they're working there for some period of time, maybe their bargaining power is less. Another consideration might be what sort of skills are we talking about here? How transferable are they to another industry if the employee actually is precluded from competing in that industry for some period of time? So it's a touch and feel type of analysis, but it's fact dependent on the issues at stake in that dispute.
And if the court, in a particular instance, finds that the equities lie in favor of the employee, will it then revise the non-compete agreement to make it reasonable?
Very, very unlikely. Delaware courts do not like to blue pencil agreements. Blue penciling is a concept used in the law to describe a situation in which the court will revise an agreement to make it conform to the law. While a Delaware court is permitted to do so, they don't like to do so because they want to incentivize an employer to get it right and to draft a non-compete that's narrowly tailored to the need. The Delaware courts are concerned with the idea that if employers know that the court itself will blue pencil an agreement to make it conform to the law, then the employer will be incentivized to take a maximalist approach toward drafting the non-competes, make them as expansive as possible, as onerous as possible, with the understanding that the court will just pare it back as is necessary. So they want to put the onus on the employer to get it right, and they want the employer to risk the non-enforcement of a non-compete as a penalty for being overbroad.
So thinking about that risk that employers bear then, is there a way for an employer to develop, a degree of certainty over the enforceability of a non-compete agreement?
There are two ways. Number one, the more narrowly tailored you make your non-compete, the more likely it is to be enforced. So for example, if you draft if you want to impose a non-compete on a salesperson, let's say, and you bar them for some period of time from competing within certain zip codes within a locale, by preventing them from soliciting current customers that bear a certain zip code, that's pretty narrowly tailored. They can compete in the zip code, they just can't pursue those customers. And it's for some period of time that's deemed to be reasonable. If you want more certainty than that, or you're concerned about the risk that however you draft the non-compete, it won't be narrowly tailored enough, and then the court won't blue pencil it. If you want more certainty than that, then the way to go is a forfeiture for competition provision. That's slightly different than a non-compete, but offers a similar function. Because Delaware is a contractarian state, they respect contracts a great deal, and they want to give parties the freedom to contract. So, if as an employer, you enter into a contract with an employee, and you offer the employee an additional benefit contingent on the employee complying with the non-compete, Delaware courts are much more likely to respect that sort of arrangement because it's voluntary on behalf of the employee. There doesn't seem to be an undue amount of pressure. The employee can choose to comply or not comply with that agreement following termination of employment. And the only penalty is that the employee doesn't get the benefit that was negotiated contingent upon compliance with the non-compete. And these forfeiture for competition provisions can have a lot of teeth because there can be a lot of money at stake in terms of the forfeiture, but the court will still find that to be enforceable. There was quite a famous case in the Delaware court system. Delaware's highest court, their Supreme Court, in 2024, rendered a decision in Kenner Fitzgerald versus Ainsley, in which employees of Kenner Fitzgerald left. They were actually partners, and they stood to lose through a forfeiture provision anywhere from $100,000 and $5 million if they competed with Kenner Fitzgerald. And the court said those forfeiture for competition provisions are just fine. These departing partners have a right to compete if they wish, or not compete if they wish. The consequence will be, if they compete, they forfeit this contingent compensation. And if they don't compete, they receive this contingent compensation. And the type of contingent compensation is subject to negotiations. It can be something as simple as severance. It could be distributions through a partnership. It could be stock options. It could be some sort of deferred compensation that is contingent upon compliance with the non-compete. And if you do it that way, you get closer to certainty in terms of the enforceability of the non-compete.
Thank you. And I think, just in conclusion then, how would you summarize the view that the Delaware courts take toward non-compete agreements?
In Delaware, non-competes are enforceable, but they are strictly construed, strictly assessed, and they have to be reasonable in terms of geographic scope and temporal duration, and they need to protect the legitimate economic need. If the court believes that the non-compete is overbroad or unduly onerous, it's most likely just going to strike it. It will unlikely blue pencil the non-compete, because Delaware courts want to incentivize employers to narrowly tailor their non-compete agreements. If an employer wants to improve the likelihood that the non-compete will be respected by a court, then the way to do it is to establish a forfeiture for competition provision, in which the employer provides the employee with a benefit the employee wouldn't otherwise be entitled to, and then makes that benefit contingent on compliance with the non-compete following separation between the employee and the employer. And that form of contingent benefit can be severance, stock options, certain forms of distributions. At this point, the sky's the limit, but it has to be an additional benefit beyond what the employee should otherwise expect from his or her compensation.
Well, that was a masterly summary. We've covered a lot of ground there, striking a balance in these agreements such that they are enforceable while still providing something useful to employers is clearly quite complicated. Thank you so much for joining us, Michael.
My pleasure. Thank you for having me.